Okay, so welcome everybody. My name's Charles Cresson Wood, and I'll be talking about the directors and officers' legal responsibilities for information security and privacy. I'm an attorney in Washington and also California. Been working in information security and privacy for 40 plus years. First with Stanford Research Institute, and then later Bank of America. And since then, I've been working with a variety of different firms, 125 different firms as a consultant and as an attorney. And perhaps you know my best selling book, which is called Information Security Policies Made Easy, which was used by 70% of the Fortune 500 companies. And I'm particularly concerned about one thing, and I'll focus upon that in my presentation today. And that one thing is that we're all connected. What you do affects me, what I do affects you. So for instance, if a large credit reporting bureau like Experian has a breach, and your credit data gets picked up by the hackers and used for identity theft, you're impacted because they did a poor job in information security. And as it turns out, the directors and officers were held personally liable at Experian for the breach that took place in 2017. I'll get into the details about that in my presentation. I apologize that the slides are not here. I was told by the organizer they would be preloaded on the machine, which is up here. So a good thing I have paper notes. Always have backups. So indeed, I have a backup. So I'll just take it with my paper notes. If we get the slides, great. If we don't, that's great too. The show will go on.
You jumped the gun. I was going to introduce you and everything.
Well, anyway, the fundamental truth, which is not being adequately addressed in our field, is that we're all connected, we're all interdependent, and the internet has made that so very obvious. And we need to be looking out for the other guy. We need to be considering the other guy in our decisions, and we need to be working together with our vendors, with our customers, with our shareholders, and with other parties when we're making decisions about information security and privacy. And in order to get this working together to actually proceed in an effective way, we need to be clear about what the duties of each of the parties are. You know, what is it that this particular vendor is going to do for us? What is it that the Information Security Department is going to do for us? Thank you. What is it that the privacy group is going to do for us, etc. Okay, so we're in this arena, this new world where we have a multi-departmental, multi-organizational interdependency, but we're not making decisions about the tools, the techniques, the procedures, the policies, the things that we're implementing in information security in recognition of that. The existing incentive systems that are used by many American corporations are based on money. And so you guys have to go through that process where you need to justify things based on ROI or net present value or some other financial metric. Well, unfortunately, security and privacy does not lend itself to a financial analysis. And what that means is we're dangerously underprotected. And so this ubiquitous nature of information security, the fact that we have to, all of us, work together on it, that means we have to be clear about our responsibilities, who's doing what. And so that's why I'm focusing today on the directors and officers, because that's where the buck stops. If your firm gets sued due to a a breach or some other problem related to security and privacy, they're going to name the directors and officers. In fact, they're going to name them individually. And so I'll be talking about personal liability for the directors and officers, including the CISO. And so the CISO, in many cases, could be considered to be an officer, and he or she is likewise responsible for a breach. And everybody got all excited with the Joe Sullivan case and what happened with Uber and how he got convicted for not divulging details about a breach. That's just a harbinger. That's just the future that's showing up on our screens. We're going to see a lot more of that in the future. And we'll get to examples of how right now directors and officers are being held personally liable. And my major point for this whole presentation is that at the very least, make sure your directors and officers are doing things that are fully in compliance with the law. And they need to be able to demonstrate that. Because if they don't demonstrate that, their insurance will not protect them. So that's great. They have directors and officers liability insurance. That's great. You have cyber risks insurance. That stuff does not pay out if they knowingly were not in compliance with the law. So you really need to look at the exclusions of your insurance. And the directors and officers in many cases are mistakenly proceeding as though the insurance will be their safety net. In many cases, the insurance will not be their safety net. And so we're coming up on the number one recommendation, and I'll have several in this presentation, but the number one recommendation I have for you is make sure your directors and officers know their legal duties. And I suggest you have an annual presentation to the board which goes over their legal duties. And I'll get into those in this presentation, but that will, of course, vary by organization. It will vary by industry. It will vary by size of the entity. It will vary by jurisdiction. But at the very least, they need to know what is it they're going to be held legally responsible for doing. One thing that the directors and officers don't really appreciate is that they cannot delegate their legal responsibilities in information security and privacy. Many of them think, oh yeah, this is a technical issue, we'll have the IT folks handle it, or we'll have the chief privacy officer handle it. It's like, no, I'm sorry. There's some things you as directors and officers need to do yourselves. You cannot delegate it to a third party. You cannot give it to somebody else on your staff. It's a non-delegable duty. And I'll give you an example. That's the duty of oversight. They have to make sure things are being done correctly in the information security and privacy realm. And I'll get into Caremark, which is probably the most important case in this area. It's already been adjudicated in the Delaware state courts. It's already been established. This duty cannot be delegated. They have to do it. Anyway, be real clear about roles and responsibilities and who is doing what. And I had when I first got into information security in the late 70s, I'm really showing my age here, I was working at Stanford Research Institute, and I had the privilege of working on a National Science Foundation grant. Back then we called it computer security, and we were identifying different ways in which computer crime and computer abuse were taking place. And usually that was where there was a gap in the systems. It was the interface between systems. It was where things have not been adequately addressed. Well, this is a big gap that I'm talking about today. The roles and responsibilities clarification is a big gap in information security and privacy. And it's a mess in many organizations if you're talking about third-party risk management. Who is responsible for paying the costs of a breach with your third-party provider? In many cases, that's not clarified. You do not want to adjudicate this. Please stay out of court. deal with all of this in a proactive way, you're going to save so much money. I should say everything that I'm going to mention today is not legal advice. It's just educational and informative. My professional association requires that I say that. It's kind of obvious, I think, but anyway, I'm required to say that. So I wrote this book, Information Security Roles and Responsibilities Made Easy, and that included job descriptions, departmental mission statements, and many other manifestations of roles and responsibilities. And we need more assistance in this area. But if you do nothing that's really spiff in this area, at least make sure the directors and officers know their legal duties. And we'll talk about that. So, it's funny how we all agree that we should have performance measurement for virtually every job. But when it comes to the directors and officers, in many cases, we're not measuring their performance. But we really do need to measure their performance. And with artificial intelligence, we're going to have a very big game change coming up in the next few years, where the gaps in your systems, the weak link in your systems, that will be identified by attackers using artificial intelligence. And there's going to be a lot more public information out there. So, for instance, Securities and Exchange Commission is now requiring 4-day disclosure for breaches. And that will be a very short turnaround time for a lot of firms to understand what happened and make a public statement about that. And that will be integrated into real-time vulnerability identification models, which will be used by the attackers. Well, how are you going to be able to defend against that? Well, you've got to use AI in order to understand what your vulnerabilities are. But before you can use AI, you have to give the AI systems good instructions. You have to give it good parameters in order to train it properly. And what I'm talking about today are those parameters as they relate to roles and responsibilities for the directors and officers. So, information security really is so underappreciated. It's become something fundamental to everything that we do in our culture. If we don't have information security and privacy, we can't get the food that we need to eat. We can't have the lights turned on. All the things that we've been dependent upon are inherently dependent upon information security. And it's your job to impress upon the directors and officers at your organization how critical information security and privacy has become, and that they cannot afford just to leave it to somebody else. They have to be involved. We likewise cannot afford to wait until there's a disaster in order to appreciate there's a problem. So if you've been following the Colonial Pipeline disaster, where they had ransomware and they shut down Colonial Pipeline, you do not want to be like Colonial Pipeline. You want to be proactive. You want to make sure these things are handled in advance. You want to make sure you did good backup, you're encrypting your backup, etc. And all right, that's fine. We got a ransomware demand. We're going to spin up a whole new production environment on an off-site location. We're going to switch our network over. We're just going to proceed as though nothing's happening, and the attackers can deal with the system that they'd penetrated, because we can go about our business anyway. We don't care. And of course, you're not paying the ransom. So Enron had some very important lessons. It's unfortunate we don't talk about Enron more. This is 2001. I appreciate some people at this conference weren't even alive in 2001. But It was a really critical and decisive situation, and it caused the Congress to pass a very important law called Sarbanes-Oxley. And Sarbanes-Oxley particularly has this section 404, which talks about a sign-off from the chief executive officer and the chief financial officer. And every year, both the CEO and also the CFO have to sign off and say, we have examined the controls which go along with the financial systems, and they're adequate. And that representation of the adequacy of internal controls is a very important legal representation. And they can be sued personally if indeed that's not true. Now we need something like that in information security and privacy, because information security and privacy is so very critical. But you can do that today. You can initiate your own third-party attorney's review of the directors and officers' performance as it relates to their duties in the information security and privacy field. And that independent attorney can produce a one-page opinion, very much like a CPA produces a third-party audit opinion on the financials, and that can be held in strict confidence and used just to improve things at your organization. And I strongly recommend that you consider having an attorney review your directors and officers and how they're doing when it comes to their legal duties. So what happened at Enron is we learned about the importance of the tone at the top. Now, the tone at the top, that's the overall corporate culture. That's the overall way in which the leaders look at the organization and how they expect the people in the organization to behave. And if the leaders are engaged in fraud and lies and doing anything to make a buck, then they're communicating to the rank and file employees, in fact, out to the third-party contractors and others, that they're going to be using that same ethical stance in everything that they go about doing, and that's okay. That's, in fact, the only way they're going to survive. So at Enron, they had something called the Rank and Yank Performance Measurement System. And the Rank and Yank Performance Measurement System said that the lowest 15% of our staff will be fired. Everybody who is the lowest 15% of performers will be fired every year. And you can imagine that's a lot of pressure to be amongst the 85% that stay. So it was taken for granted. You had to lie, you had to cheat, you had to do what you had to do in order to show profits and make money. And if you followed what happened at Enron, they created offshore entities, they engaged in all sorts of outrageous accounting fraud, and it came to light. Ken Lay, the president, he went to jail. It was a big deal. And we need to come back to what is the tone at the top. But for our purposes, as it relates to information security and privacy, what is the tone at the top of your organization? Do the directors and officers communicate to everybody? This is really important. We need your help. Everybody has a role to play, either as a data custodian or maybe a data owner or a data user or something else. Even if you're not in information security and privacy, you still very much need to follow the policies and get your training and do these other things. We need those types of messages to come from our board and come from our executive suite. So Section 404 in the Sarbanes-Oxley Act actually requires a signature from the directors and officers saying, yes, I've reviewed the controls and they are adequate. Do your directors and officers put themselves in a position every year where they can say that about information security and privacy? where they know that the controls are adequate. I'm still surprised at how infrequent the presentations to the board of directors are at major companies, like annual presentations to the board. If you're a CISO, you should be giving quarterly presentations to the board about information security and privacy. You should be presenting the results of the GRC system, the governance, risk, and compliance system. You should be talking about progress that they've made and things on the horizon. You should be raising their level of awareness. Very important. Once a year will not do it. So that's my second recommendation. At least every quarter, report to the board about your progress in information security and privacy. We're seeing, if you're paying any attention to this, I'm a lawyer, so I pay attention to this, and that's my specialty is directors and officers' personal liability for information security and privacy. Wrote a book about it, in fact, which is entitled Corporate Directors and Officers' Legal Duties in Information Security and Privacy. Anyway, if you're paying attention to this, you'll see there's more and more pressure from the regulators. They're saying, we're going to go after these people personally. Now, it used to be they would just go after the corporation would pay a fine, that was the end of it. That's no longer working. It's obviously not working. You guys know it's not working. I don't think anybody who's working in this field can, make a decent argument that things are working in information security. Just follow the Ponemon IBM annual report about cost of a data breach, and you'll see it's getting worse and worse and worse every year. And part of the reason that they're going after individuals is that they realize this approach they've been using is not working. They've got to go after the decision makers to get the decision makers to take all of this seriously. And I won't go through all of these, but there's lots of different pieces of evidence to indicate that, SEC commissioners and attorneys generals of different states, particularly California and New York, they're the most active in this area, but the Department of Justice as well, they're all saying, yes, we're going to go after directors and officers in corporations individually. And they used to have what they called a clear plan. And so a clear plan was where you would let the directors and officers off without any personal liability. You would just give them a way in which they could continue to hold on to their job and just get a fine for the corporation, effectively a slap on the wrist, maybe a deferred prosecution agreement or something to that effect. But more and more, that will not be the way we proceed. We're seeing a bunch of cases that recognize the personal liability of the directors and officers. So, you don't have to wait. You can go about auditing directors and officers right now. There's no legislation or regulation that is necessary. Everything that you need in order to perform an audit of their legal duties is already out there. And I'll just provide a couple examples of the many sources that define what exactly are the legal duties of the directors and officers. The Model Business Corporations Act is one place where you see very specific fiduciary duties of the directors and officers. We have, I mentioned important cases like the Caremark case. You have a number of professional compilations of the law. Typically that's put together by American Legal Institute in Philadelphia. But we have professional standards defining what's expected. We have a whole slew of regulations, HIPAA, etc. So there's a lot for us to look at. And we've already defined how we would go about doing an independent audit. And that's what this slide is about. Since the 1930s and the stock market crash in 1929, when we had independent audits of publicly listed corporations, we've known how to go about doing these independent audits. And to have a third-party auditor perform an independent audit is not a foreign concept to the directors and officers. They go through it every year. And this same approach can be used by an attorney to look at their duties in the information security and privacy area. Everything we need is right there. I talk about this in my book. We have ethical standards for the attorneys, and how do they keep the information confidential with attorney-client privilege, with what's called the attorney work product doctrine. All these are ways in which you can prevent the findings and the communications that the attorney involved receives as a result of doing their audit. You can keep that absolutely sacrosanct. No third party's going to get that, even in a lawsuit. We have professional licensing standards, which also will ensure that an attorney will do a good job for you. They can lose their license if they're reckless or if they're negligent. Of course, we can get attorneys to evaluate the work of other attorneys. Was that done according to all of these standards? So unfortunately, in order to be believable and credible and trustworthy, we're backed into a situation where we have to question, what does it take in order to get a result which will engender trust? So this is especially important if your firm has just had a breach. Well, how do you rapidly restore confidence in your firm? Well, you can go through such an audit as I'm discussing right here and provide that to interested third parties, such as your insurance company, to get a reduction in your premium, or if it's a business that you're doing business with, a business partner, you can get their confidence that you have made the corrections that you needed to make and you're now back on track. So this whole area of third-party risk management, TPRM, is in need of some very significant additional attention. And I suggest that that would be a good place, if you have a critical supplier, a good place to evaluate whether or not the directors and officers at your third party, are they in fact doing everything that's required by law? And you can write that in the contract. The right to audit is a very important thing to write in your contracts with third-party suppliers. You may also want to evaluate the directors and officers whenever you're considering getting into an engagement with a third party, not just when it's time to do an annual reevaluation and renewal of the contract. If you're going through mergers or acquisition, you want to do your due diligence before that transaction goes through. That's another good time to evaluate whether or not there are hidden risks that the acquiring firm is taking on, and that would be a good time to do such a legal audit as this. If you're assessing whether or not the firm is a good candidate for directors and officers liability insurance, that's a great time for an insurance company to do this evaluation of the work of the directors and officers. Are they, at the very least, doing what's required by law? And we hope they're going much further. We hope that according to the risk management decisions that are going on at your firm, they're going much further than just doing the minimum required by law. But what I'm talking about here is checking to see that at the very minimum, are they doing everything that the law requires? And heaven forbid you do get into a tangle with a Federal Trade Commission or some other regulator. This is a great way for your organization to show good faith, to show the regulator you're on the mend and that you're correcting the problems. And in fact, that has been required by the FTC in the Facebook consent decrees, and that has been required in a number of other cases that the FTC investigated and settled. And so what's really great is if you're doing all this on your own without the prompting of a breach, without the prompting of a regulator investigation, you're just having documentary evidence provided by a third party, a credible third party who's demonstrably independent, that's time and date stamped, indicating that as of a particular date, your directors and officers were actually doing everything required by law. That'll be very important if you find yourself in court or on the other side of an investigation by the Federal Trade Commission or some other regulator. So I'm suggesting that it's a good idea to just do this in a strictly internal, strictly confidential basis. Just go through a couple iterations every year just to get a sense for, are you at the very least where you should be? Get some information about remedial actions that should be taken. That's not disclosed to any third party unless you need to make such a disclosure. And so it's an internal feedback mechanism that builds confidence. And as we've seen with CPAs and the issuance of so-called clean opinions, it's possible to get a fully compliant opinion about the directors and officers doing everything that's required of them in the information security and privacy area, and getting that every year, like clockwork. This is fully possible. You use pre-audits. You have some sort of a system for checking up on audit findings from last year's report. You want to make sure those things were corrected. You want to be tracking new developments in the law and related things to make sure that you're going to come through this year's audit in a way that results in a fully compliant professional opinion. Fully possible. We know how to do that. This is not rocket science. You can do that today. Everything you need to do that is available at this point in time. So I talked about some definitive sources of law you can look to. I won't go into that in further detail for want of time here, but I'd like to speak about the 6 fiduciary duties of all directors and officers. And fiduciary duties are, they're there if you are in a state which uses English common law. So that's every United States state, territory, possession, except Louisiana, which uses the old French law, which is a whole different system. You have to make certain adjustments for Louisiana. But in every other state, these 6 duties apply. And this is the type of thing you would be talking about with your directors and officers. You would be acquainting them with their duties and what that means in terms of information security and privacy. And so let's just talk about the first one, which is probably talked about the most, the duty of care. And basically that requires, and of course this applies to CISOs too. It's not just board members or the chief executive officer, chief financial officer, anybody in the C-suite who could be considered a legal officer. Now, mind you, there's been title inflation out there. A lot of people are being called officers or directors or whatever, and they're not legally directors or officers. So you need to identify who could be considered a legal director or a legal officer in order to assign these legal duties. But once you do that, there are 6 specific fiduciary duties which will be required of every organization. Doesn't matter what industry you're in, doesn't matter your nonprofit, doesn't matter your for-profit. does not apply to government. So this is only private sector. So the first one is this duty of care. And the duty of care says that the directors and officers have to be alert. And I'm summarizing the law. That's why I'm reading a little bit here. So apologize. I'm reading because of the want of time, just wanting to get useful information to you guys in a small time segment that they gave me. The duty of care talks about being alert and paying attention. And so they have to notice corporate problems when those problems occur. And they have to make inquiries, and they have to initiate investigations as appropriate to then be able to rationally act, to be able to make important decisions to correct problems. And that includes implementing a reasonable system of internal controls. So, okay, what's an example of that in the information security and privacy area? So you would look, for instance, to see whether or not the job descriptions of the senior officers have something in there about risk management. Are they explicitly charged with risk management? You may not identify information security and privacy specifically, but there needs to be something in their job description about risk management. That would be a manifestation of the duty of care. Now, mind you, there are a lot of different controls which will manifest the duty of care. In my book, I identify several hundred of them, but what you want to do is you want to get good, practical, generally accepted control measures like a job description that you can point to if ever you should be investigated by the FTC or find yourself in a court of law defending against a shareholder suit or some similar action. Okay, moving on to the second of these, the duty of loyalty. The duty of loyalty refers to the duty to act in the best interests of the organization, not to act for themselves, but to act in the best interests of the organization. So Experian, the Credit Reporting Bureau, for instance, they had a breach. You all read about that giant breach. They waited a whole month before they disclosed the breach. Now, that is not acting in the best interests of the corporation or the third parties. I was talking before about how we're all connected. Well, those of us who were affected by the breach, we need to know so we can take precautionary measures. They waited a whole month after they found out about this before they publicly released this. That would be inconsistent with the duty of loyalty. And why did they wait a whole month? Well, they wanted to sell their stock, and so not have to suffer the loss in the price of their stock. And needless to say, that's not in keeping with the duty of loyalty. So the duty of loyalty says they need to not misuse their position and the access to information that their position provides. They need to use that information in a way that's in the best interest of the corporation and the other constituencies that they're serving, such as the corporation's customers. Okay, what's a control example of that? Well, the board would periodically review the compensation system that goes along with the executives. And they would want to look and see, is it actually creating the performance that we would like to see? And if it's all about money, like it was at Enron, I suggest it's probably not doing right by information security and privacy, and you probably want other ways to evaluate their performance. That would be in keeping with the duty of loyalty. So the duty of good faith is similar to the duty of loyalty, but it refers to the duty to carry out one's duties responsibly and honestly, and to follow the norms of organizational governance. And that obligation has huge implications for information security and privacy, and this is where you can bring in third-party models like COBIT from the Information Systems Audit and Control Association, or you can bring in standards like ISO 27000. Those are normative standards of best practice, and your directors and officers have a duty to be using these normative definitions of good practice in the way that they're going about doing things. And a control example of this duty of good faith would be a code of conduct for the directors and officers. If you don't already have a code of conduct in your organization, I strongly suggest you adopt a code of conduct. That's one of the things that the government looks at when they investigate your firm. The Federal Trade Commission wants to see you guys were serious about following the law. And a code of conduct is a good way you can ensure your directors and officers are following the law. Okay, fourth on this list is the duty of disclosure and the duty of candor. Once again, all these are fiduciary duties. And the duty of disclosure talks about providing decision makers with the information that they need in order to make good decisions. And so before I mentioned Experian, I'm picking on them today because they're such a good example. They didn't give the information to their customers or their business partners in a prompt and diligent way. That would be a violation of this duty of disclosure. We need to recognize the fact we're all in this new automated ecosystem together, and we need to work together recognizing that fact. And the duty of disclosure would ensure that these decision makers disclose that information to people who have a need to know. It also means that if you get information from third parties, say you're an outsourcing firm, you receive PII, private information, personally identifiable information, you need to protect that. That's the duty of disclosure and candor. So it goes both ways. You need to keep certain things quiet that you've been told to keep quiet, and you need to disclose certain things that you're expected to disclose. And then the duty of oversight, I mentioned that before. That's also called the duty of to monitor, and that requires of directors and officers that they establish and use reasonable information systems to monitor the organizational performance. And very importantly, that includes the compliance with the law. So your directors and officers need to be monitoring, how are we doing when it comes to compliance with HIPAA? How are we doing when it comes to compliance with GLBA? How are we doing when it comes to compliance with whatever laws and regulations you may need to abide by? And a control example of that would be a loss history, where you're keeping a detailed record of all the events that took place at your organization. You're analyzing those. You're making remedial changes in light of those losses that took place. And you're making sure that you're learning from the events that took place. I strongly suggest you're keeping a good loss history. And the last last fiduciary duty I'll mention today is this duty of obedience. Lots of people don't even acknowledge that this exists. This is a real legal duty, the duty of obedience. And what does it mean? It means that the directors and officers need to follow established policies and procedures. They need to be in compliance with the organization's own policies and procedures. They need to be in compliance with the ethics statement. They need to be in compliance with the laws and the regulations and contracts and other legal agreements that they have entered into. And if they're not, they can be held personally liable. And what's a control example of that? That would be a project management system where you're using a GRC system, governance risk and control system, to report on how your staff is doing in terms of, making sure you're fully compliant with all the laws and regulations and other legal agreements to which your organization has agreed. So I want to just mention the fact that even if the directors and officers at your organization are very resistant to any discussion about their legal duties, even if they're the most narcissistic just thinking about themselves types. They don't care about anybody else. Even if they're that type of a narcissistic leader, they should care about this. And they should care about this because there have been a lot of examples where executives have lost their job. In fact, there's a new study, Kaspersky Labs just came out with a survey about a week ago. 42% of the breaches in America resulted in some director or officer losing their job. That's a lot of directors and officers losing their job. That could be you, the chief information security officer, but it could also be the CEO, as it was, for instance, at Experian. Other things that might happen to them, they would lose their reputation as a good manager. They may not be hireable again once they got fired. They may not have their stock options exercisable at a price that would be in their favor because the stock took a major dive as a result of the breach that took place because they were not in compliance with their legal duties and obligations. And many of them, as I mentioned, they're overestimating what insurance will do for them. And there are actually many ways the insurance companies, if you read the contracts, many ways the insurance companies can deny coverage. So knowingly being in violation of the law, that will be enough for the insurance companies to, according to the terms of the contract, deny payout on your directors and officers' liability insurance. And they may personally be required to pay regulatory fines. They may have to pay civil suit damages. A good case to look at is Solar Winds that just got settled a little while ago. In that case, the directors and officers had to pay out of their own pocket to the shareholders for their breach of fiduciary duties because of deficiencies in the information security and privacy area. And it may be like Joe Sullivan. They may go to prison, and that doesn't say anything about how that affects you personally. If you go through any high visibility lawsuit, it's a very taxing experience personally, and certainly not desirable from an interpersonal family perspective. So in the want of time, let me just mention defenses. If you're still not able to interest your directors and officers in a conversation about their minimum legal duties, you might be able to talk about how if they went through such an audit by a third-party attorney, they would actually achieve a number of legal defenses that will cover their backside if they were to be sued, if the FTC were to investigate, etc. And just like to mention a few of those defenses, and these will work in court to get you off so you won't be personally liable. A good faith reliance on the advice of independent legal counsel. That was the attorney who did the audit. You're relying upon the result of the audit. And that attorney said, these are your legal obligations, and okay, fine, we're taking action based on what the attorney said. That is a very compelling, what they call affirmative defense in court. And another one is reasonable reliance on the advice of experts and subordinates. And so that's the key word, reasonable there. You have to be receiving the advice of experts, and you have to be incorporating that advice of experts in your decision making in a reasonable way in order for you to use this defense. You can also make a case that you demonstrably were in adherence to all the norms of corporate governance. You did what was expected of you, and you got this third-party time and date stamped certification from a third party. Maybe it's ISO 27000, third-party certification, those types of things. They're going to be a lot more popular in the years ahead. You're going to see a lot more of that. The most powerful defense, of course, is the business judgment rule. The business judgment rule says that you made a decision which you believed was in the best interest of the corporation, and used all the information that was reasonably available to you in order to make that decision in a manner that a prudent person would be making that decision. The problem is the directors and officers are not getting the information. In many cases, for instance, I mentioned a study by Kaspersky Labs, 41% of breaches are not passed up the chain to the directors and officers. They don't even know these things happen. And that's a major problem. If they don't even know these things are happening, then they can't get the information they need to be making good decisions about funding and staffing and other things in the information security area. One of my favorite defenses that will protect your directors and officers is it would be unreasonable to expect the directors and officers to be able to anticipate this particular attack. There had been nothing in the past to indicate that this type of attack would be something that they need to defend against. So this would be appropriate for 0 days that are a completely different type of 0 day. And they did everything that they needed to do, updating software from vendors, etc. And this is just beyond whatever they could have conceived of. That's a great defense, and that will protect them as well. And likewise, there will be another defense they could use. There's nothing in the generally accepted group of controls that could have protected and prevented this particular attack. And if you can prove that through a third-party audit, then that's a great defense as well. And I like this. This whole notion of being on notice is very important for you to talk about with your directors and officers. If they're on notice of an incident, then they have an obligation to respond. They cannot be like an ostrich and just ignore that. They have a duty to respond. And so if you can make a case that there was no prior incident and the directors and officers had no way to know that this is something they should be protecting against, that would be a good defense as well. Well, how do you do that? You do these audits I talked about. You have a loss history. You analyze the losses that you've experienced. You're up on top of, the different problems that are encountered by people in your industry, etc. So to, get back to how do we affect the behavior of directors and officers in a positive way so they will put greater emphasis on information security and privacy, how they'll do the right thing. Well, we need to get away from so much emphasis on financial metrics. We need to open up other metrics. I think the best alternative metric is, are they doing everything that is at a minimum required by law? I think that's easy. That's something that's readily determined. We know how to do that. Relatively inexpensive to have a third-party lawyer do that. And it also establishes some balancing way in which your directors and officers are evaluated. And if they have several of these alternative metrics on which their bonus is based, on which their performance is based, then they're going to be acting in a different way. And I suggest this whole notion of, are you demonstrably doing the minimum required by law, is widely applicable across all firms, and you can use it in third-party risk management. You can use it in many other decision-making contexts. It's not just for, establishing a new and more effective incentive system for your directors and officers. And I'll just mention a few of the cases. We don't have time to go into them in detail, but if your directors and officers think, oh, this is some futuristic conversation, we don't need to worry about that now, you should have a couple of these cases in your hip pocket so you can pull them out and talk about them. It's like, yes, directors and officers are being held personally liable. They have to pay out with their own money. They're losing their job, etc. They're losing their reputation, etc. Probably the most influential is the Caremark study, and that you can look it up. That's the duty of oversight. But really what that established was the non-delegability of certain duties, like the duty of oversight. The directors and officers have to do certain things. Stone versus Ritter, another very important case, and that case established this duty to take remedial action. If you are on notice that there is a problem, the duty of good faith requires that you remedy those problems. Another case, the estate of Leamington, that's the duty of loyalty. That says you have to have good people, and you have to make sure that those good people are performing up to snuff to do the job that needs to be done in the information security and privacy area. If you know you have underperforming people in information security and privacy, you need to train them better or get rid of them or outsource it or take some other action. That's the duty of loyalty to the corporation's interests and not their own. And in this case, it was nepotism. You can imagine nepotism would keep people in a position where they should not be, and that was a major problem leading to an information security problem. So another case I thought was very interesting was the CEO in Physicians Healthcare authorized a blanket fax to people, and that was a violation of the law, and that made him personally liable. So that's an interesting case for you to cite, and if there are any lawyers in the audience, you'll be intrigued about where this is going. There's increasingly this conversation about negligence per se, and the way negligence per se works, and if there's a generally accepted set of principles for information security and privacy, but it doesn't necessarily apply to this case, but it is generally accepted in the industry, we can expect the directors and officers to comply with that generally accepted practice. And negligence per se, in this case, allowed a very enterprising plaintiff's attorney to get the right of private action under HIPAA. Now, if you know about HIPAA, HIPAA does not permit private parties to bring a lawsuit. And so that's how this private party was able to bring and win a lawsuit establishing directors and officers' personal liability using the controls required under HIPAA, even though HIPAA did not in itself establish the right of action for individual plaintiff. Anyway, I should wind up just to leave you with a couple of the big numbers that we're seeing. A lot of cases out there, a lot of money. Facebook got fined $5 billion. That's the biggest fine ever. That was for the Cambridge Analytica case, you probably remember. But this is no longer chump change. Directors and officers can't ignore it. You can see an analysis of this in my book, but appreciate your attention, and I'm happy to take any questions offline.